suitcase, take it everywhere I go. Well, you know, it's just a big old bag of trouble. Trouble's all that I know. I met a girl who fell in love, and our love was true. I met a girl who fell in love. You know our love shown up true. Then you know I found out she had a big old suitcase too. So we put our bags together, yeah.
All right. So, as you know, I continue to give you guys valid information. I show you where it's at. I give you the source. Yesterday, I did something I typically don't do because it's a pain in my ass, but I shared the information through email with a few people to give to you guys. All right? And I think, it appears anyway, that everybody is being serviced that way. And if we continue that, I will continue to share this information with you via an email. All right, so long as everybody else is going to participate and share on the information. So today we'll pick up where we left off yesterday. This sovereign individual paradigm is explained by the following U.S. Supreme Court case. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. Article 1, Section 10. He owes no such duty to submit his books and papers for examination. That would be the Fourth Amendment, the right to be secure in your papers, houses, persons, and effects. Okay? To the state, since he receives nothing therefrom, beyond the protection of his life and property, which is what government was instituted amongst men for. It's in the preamble of the Constitution, all right? All right, pay attention, because I'm fucking just drilling you with the knowledge that you need to have proper standing, all right? He owes no such duty to submit his books, papers, and for an examination to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land, natural law, God's law, common law, long antecedent to the organization of the state. Now, when we're talking about common law, what are we talking about? We're talking about the Seventh Amendment, ladies and gentlemen. If you read these fucking documents I'm telling you about, you guys will have the confidence to be able to tell these wankers to stick it where the sun doesn't shine, all right? And can be taken from, his rights as such as existed by the law of the land. Common law, God's law, natural law, long antecedent to the organization of the state, and can only be taken from him by due process of law. Notice an opportunity, a contract in their commercial realm must be had, and you must have a meeting of the minds. A contract must be mutually beneficial for all parties involved. Now people go, well, Derek, wait a minute. They're putting us in fucking jail, dude. How's that beneficial? Well, they consider it a benefit, not a punishment. They're giving you 3 fucking hots and a cot, and they consider that adequate living in their mindset. The way that they look at things, that is a benefit. You're receiving a benefit while they whisk away your securities and unjustly and fucking rich themselves while laundering money. Okay? And yes, I know this shit to be a fact. Among his rights are refusal to incriminate himself, Fifth Amendment, and the immunity of himself and his property from arrest or seizure except under a warrant of the law. Again, Fourth Amendment. He owes nothing to the public so long as he does not trespass upon their rights. Hale versus Henkel, 201 U.S. 43 at 47, 1905. Let us analyze this case. It says the individual may stand upon his constitutional rights. It does not say sit on his rights. There is a principle here. If you do not use them, you lose them. You have to assert your rights, demand them, stand upon them, fight for them, because freedom is not fucking free. Nowhere in the Constitution does it say this is without him mentioning it. Obviously, it should be that way, but it doesn't state that. So you got to stand upon your rights and know who the fuck you are, because you have free will. You have choice. You could fall underneath and be subject to their political bullshit if you so choose. It is an option you have. That's why I say I have no ill will or animosity towards U.S. citizens. You want to be a U.S. citizen? Fucking go out there and pay your fucking taxes, all right? I appreciate everything that you're doing by being willfully fucking ignorant in an age when people like myself are pouring their heart and soul out giving you factual fucking information to pull you out of the gutter, all right? But if you wish to be a U.S. citizen, you firmly believe that your tax dollars are actually going to something useful in this fucking country, you go right ahead and support and sponsor terrorism. You don't think you fucking sponsor terrorism? Let me just show you something. Ask yourself this question. Has any of your tax dollars ever been spent by a politician to solicit sexual lewd conduct from minors? Do you know? Okay, because I'll bet you it fucking has. Has any of your tax dollars, which you believe to be tax dollars that are going to your roads and your schools and everything else, because they get funded a completely different way than fucking tax dollars. They get funded by that Social Security account number, all right? So your tax dollars are really a gift and estate tax, all right? You can ask a CPA how many class taxes there are, and they'll probably say something like 5. The truth is, there's 9. The question is, how do I know more about what a CPA should know about than the CPA knows? Because they're compartmentalized to only know a certain amount of their duties, rights, titles, and obligations to their clients and customers, okay? Ignorance of the law doesn't excuse anybody, but they'll lean upon the fact that, well, it's just customary. We do Class 2 and Class 5 taxes. I mean, I only thought there was 5. There's actually 9. Guess how many of them apply to you as a man or a woman? There you go. But the estate is a different thing. The trust is a different thing. The S-Corp is a different animal all in itself. So, again, you have free will. Next it says, he is entitled to carry on his private business in his own way. That means unfucking molested. And it's also reaffirmed in Article 1, Section 10, where it says we have the unlimited right to contract, which means we also have the unlimited right to tell people to go fuck themselves when the deal doesn't seem to benefit us in any way, shape, or form. Okay? So, what do they do in the court system? They proceed to violate the Hobbs Act. What is the Hobbs Act? Well, since they know that you're intelligent at this point, you've obviously done a little reading, the next thing they're going to do is they're going to put you in a fucking cage. They're going to tell you that they are not going to release you until you sign a fucking bond, whether it be a PR bond or you actually cash bond, whatever the fuck it is. That's extortion, okay? And that falls underneath the Hobbs Act. Are you paying attention? Write this shit down, because I'm not going to repeat it over and over and over again, and Facebook likes to take down my videos. Hobbs Act. How? Because they issue a capias, purported to be a fucking warrant, a gun-toting moron comes and picks you up, not knowing any fucking better, because he's been ordered by the judge, which he doesn't even realize is just an administrator, utilizing him to orchestrate the RICO racketeering scheme to unjustly enrich themselves and launder securities. Bingo, got your asses. All right, so with that said, that's where the Hobbs Act comes in. Because the sheriff comes back and says, until you sign this fucking piece of paper, you can't get out. That's compelled performance, all right? And then if you restrict your endorsement, oh, you gotta sign that again. Well, where's the law that says that, dickhead? I can put my mark, signet, and seal any way I fucking see fit, and if you don't like it, that's tough fucking shit. What interest do you have in the security anyway? Huh? Are you paying the transfer tax? Are you handing this to the prosecutor, the clerk, the judge? Who is this instrument going to? Who's funneling this negotiable instrument, you little fucker? Because under Title 26, 2603, 2602, 2001, 2002, you're responsible for the transfer tax on a carryover basis. Then there's a taxable determination that needs to be paid for the taxable determination on the order that was signed in the first fucking instance that created another fucking security. All right? So who's paying the taxes here? Who's going home with you tonight? Is it Big Bubba in a cell? Or are you going to pay the piper, make sure the United States Treasury isn't incurring any harm, damage, and loss, and that the beneficiary is made whole? The beneficiary is now here and known, period. Also the entitlement holder. So I can give you fucking orders, too, if I feel like it. Under the Power of Appointment Act of 1951. No, this is all in my head. Power of Appointment Act 1951, and now appoint you trustee. I accept your oath of office, your Article 6 oath of office, your Title 5 101 oath of office, your Title 4 101 oath of office, and your state constitutional oath of office. I invoke them, I accept the contract, and I bind you fucking to it, you little fucker. Now go get my securities and bring them forward, and let's have a full accounting done on this fucking matter so we can settle out these books, zero the accounts, and make sure all the rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattel securities, trust residuals, assets, rents, profits, and proceeds, futures and security, futures and annuities are paid directly to me, the beneficiary. Fuck off. Or we're going to go ahead and notify the SEC, the OIG, the Secret Service, because we have reason to believe that you may be using these funds for nefarious activity that may be a matter of national security. And that's far be it from me to make those decisions or that assessment, but I'm going to turn it over to somebody who can make those assessments, that is charged with the duty of making those assessments, to make sure that I'm not buying fucking bombs for the Taliban for fucking dickhead Biden, all right? We have a duty to quit selling ourselves out and letting these motherfuckers pimp us out to foreign nations so they can breed war and bloodshed and aggression against Americans. We're at fault here. We're the reason this shit's occurring. We wouldn't give them a blank checkbook by letting them wander off with our securities while claiming they're abandoned. They wouldn't have a blank fucking checkbook. Are you following what I'm saying? I'm trying to tell you the court system is a $10 trillion a year industry that has never been put on Forbes fucking magazine. That should piss you the fuck off. But anger's a good thing. If you know how to harness it, channel it, use it for something good and constructive, anger is a powerful emotion that you can utilize to manifest greatness into existence for your community. So let's harness that energy and channel it the right direction. Next, it says, he is entitled to carry out his private business in his own way. It is private business. You have a right to operate a private business. Then it says, in his own way. It does not say in the government's way. Okay? They have no authority. The legislator has zero authority over you to tell you how to do your fucking shit. All right? If you want to be a plumber, go be a fucking plumber. It's none of their fucking business. Okay. Then it says his power to contract is unlimited. Article 1, Section 10. As a sovereign individual, your power to contract is unlimited. In the common law, which is the Seventh Amendment, there are certain criteria that determine the validity of contracts. They are not important here, except that any contract that would harm others or violate their rights would be invalid. For example, a contract to kill someone is not a valid contract. Apart from the obvious qualifications, your power to contract is unlimited. Next it says, he owes no such duty to submit his books and papers for an examination. Again, that's the Fourth Amendment to the state, since he receives nothing therefrom beyond the protection of his life and property. It's also the Fifth Amendment. You have the right not to incriminate yourself. The court case contrasted the duty of the corporation, an entity created by government permission, feudal paradigm, to the duty of the sovereign individual. The sovereign individual does not need and didn't receive permission from the government, hence has no duty to the government. Why? Because he who creates is master, and man created government to benefit mankind. Period. Then it states, his rights are such as existed by the law of the land, common law, long antecedent the Seventh Amendment, to the organization of the state. This is very important. The Supreme Court recognizes that human rights, or the rights of man, have inherent rights. The U.S. Constitution, including the Bill of Rights, does not grant us rights. We have fundamental rights, irrespective of what the Constitution says. Let's talk about some of those inherent rights, all right? You have the right to breathe, you have the right to die, you have the right to sneeze, you have the right to shit, piss, shave, shower. None of that shit is written. None of that is enumerated. And when we read Article 9 of the Constitution, Amendment 9 of the Constitution, it's very fucking clear that anything that is not vested in the government is retained by the people. All right? So you have the right to masticate, masturbate, urinate, defecate, sneeze, cough, fart, puke, whatever the fuck you want to do. You have the right to drink yourself into a fucking oblivion, and it's not even mentioned in any of the paperwork. All right? So when we're talking about unalienable rights and understanding your substantive rights and the rights that existed long antecedent to the creation of the state, which means those are supreme and superior to anything the state legislator creates, all right? Because it doesn't fucking apply to you. You've never registered to sell alcohol, tobacco, and firearms, so you don't qualify under Title 27 and Title 26 to pay an income tax of any sort, unless you choose to volunteer, which there's a little excerpt that says, should a person desire to pay taxes, you must give them the W-4 form. You must give them a W-2. Okay? So it's about reading and comprehension and understanding what's really going on. If you want to be willfully ignorant and go ahead and subject yourself to be subservient to these Satanist, sick, pedophile fucks, then by all means, go ahead. But for me, it's an issue of morality. I can't sit by idly and watch these fucking lying, looting, pandering fucks usurp power otherwise not delegated to them, aka authority, all while extorting people for their own nefarious, unjust enrichment and fundamentally funding criminal activities such as giving Taliban F-16s, F-15s, fully automatic weapons, mortars, some of the state-of-the-art fucking military technology that the United States has. I just don't believe in funding that shit. So, let's carry on. Finally, the Supreme Court says he owes nothing to the public so long as he does not trespass upon their rights. The sovereign individual does not have to pay taxes. If you should discuss Hale versus Henkel with a run-of-the-mill attorney, he or she will tell you that case is old, okay? It doesn't have any more merit or precedent anymore. We've pushed beyond that in our hinkling to fuck you all out of your sweat equity, all right? We're beyond that. Well, I'm here to tell you the Seventh Amendment has never been repealed, ladies and gentlemen. All right, if you understand the process to pass an amendment to the Constitution, I mean, it's almost fucking unheard of how difficult it is to amend the Constitution. Although it's been amended, 28 times? And I think they were trying to do a 29th where the 29th was actually going to state something along the fucking lines that everything they passed not only applied to the people, but also applied to them. And then later on in my studies, I realized why they couldn't say it applied to the people. Because they don't have that fucking kind of authority. But it's very clear that if they create something, it actually fucking binds them. He who creates is bound to obey. All right? And in order for the government to create anything, first they have to have subjects that are bound to obey it. All right? Well, I'm only bound to obey the Heavenly Father. There is nobody else that I'm bound to obey. I'm supposed to be doing His good works. I'm supposed to be showing people all the ropes and helping them stand on their own against these fucking cynical assholes who are really demons in disguise that practice deviling through a twisting and manipulation of the language, all while absconding from their rights, titles, duties, and obligations to the American people so they can unjustly enrich themselves. And I'm here to show you how to stand the fuck up and give it to them. All right? So, we're going to keep going through here. If you should just, we already covered that. We know that Hale versus Henkel was decided in 1905 in the U.S. Supreme Court case. The lawyer is going to tell you that it's old and that it has been overturned. If you ask that attorney for a citation of a case or cases that have overturned Hale versus Henkel, there will not be a meaningful response. We have researched Hale versus Henkel, and here is what we found. We know that Hale versus Henkel was decided in 1905 in the U.S. Supreme Court. Since it was the U.S. Supreme Court, the case is binding on all courts of the land, until another Supreme Court case says it isn't. Has another Supreme Court case overturned Hale versus Henkel? The answer is no. As a matter of fact, since 1905, the U.S. Supreme Court has cited Hale versus Henkel 144 times. A fact more astounding is that since 1905, Hale versus Henkel has been cited by all of the federal, state, and state appellate court systems over a total of 1,600 times. None of the various issues of this case has ever been overturned. None of them. So, if the state, through the office of judge, continues to threaten or does imprison you, they are trying to force you into the state-created office of person. As long as you continue to claim your rightful office of sovereign, the state lacks all jurisdiction over you. The state needs someone filling the office of person in order to continue prosecuting the case in their courts. A few weeks in jail puts intense pressure upon most persons. Jail means the loss of job opportunities, separations from loved ones, and the piling up of debt. Judges will apply this pressure that they attempt to arraign you. Well, let me tell you something. If they throw you in fucking jail for contempt of court, immediately you have a right to allocution. First and foremost, they're fucking completely blowing due process out the water, right? They're pretending that they have this mystical jurisdiction over you, that you entered it into a contract, and they can tell you to go to your fucking room when they want to. All right, that's an egregious misnomer. First of all, it's a violation of due process of law. Who's the injured party in here bringing the contempt charge? Who in here is claiming harm, damage, and loss by my actions? You better fucking stand up and sound off like you got a fucking pair. Secondly, there needs to be a hearing on this matter because innocence until proven guilty is a fucking fact in this nation. So you're not going to sit there and be the judge, jury, trier of the fact, and executioner of your own fucking claim. One, it's unbecoming of the judge. Two, it violates the canon laws. And three, I don't put up with that fucking shit. So you can go fuck yourself. All right, we're going to have a meaningful hearing and trial, and you're going to put on the record, you're going to independently bond the case first and foremost. You're going to put on the record your facts established in a statement of facts structured as an affidavit or an affidavit. You're going to allow me to depose you, and you're going to sign it with a wet ink motherfucking signature under your full personal and commercial fucking liability, you shit stick. That's what's going to happen. All right? You're not even going to get that far and say, oh, fuck it, never mind, we don't want to do that. We don't need to go that way. Yeah, of course not, because none of you guys can swear under the pains and penalties of perjury that have caused you harm, damage, or loss. I'm, after all, just here to settle this fucking matter, and you motherfuckers are over here trying to run a gamut on me, violating a litany of your own statutes, codes, city ordinances, rules, regulations, and policies that in fact bind your asses, not mine. Okay? You're criminals, and you're laundering money. And you can deny it till the fucking cows come home, and ignorance of the law excuses no one. We'll let the IRS determine what the fuck you're doing. We'll let the SEC determine what you're doing. We'll let the FTC determine what you're doing. We'll let the Secret Service and the FBI make an evaluation of what they're fucking doing, because after all, they're licensed by the licensor as a licensee to go ahead and investigate your fucking asses. All right? And while that investigation's going on, I'm going to go ahead and file some bar grievances to the Judicial Committee, and we're going to go ahead and expose you guys for violating not having registered DBAs, assumed business names, for not having your foreign registration certificates lodged with the Attorney General and keeping them up to date on what the fuck you're doing on my land, okay, and how you're conducting your business. All right, you don't have a letter of good standing from the IRS to even fucking be here, so you have no standing and no jurisdiction just on that grounds alone. Under Title 26, 2032, AE11, you're required to fucking turn around and be independently bonded with the Secretary of the Treasury, and you've already admitted by omission, by looking stupid like a deer in the fucking headlights because you never learned that in law school, that you haven't been compliant with that. Someone needs you to fill out a 433A and a 433B, and if you won't do it willfully and voluntarily, since you brought these falsified claims and records without having firsthand superior knowledge, and you're not the attorney in fact on the record or the attorney of record on the court. I don't see any filing of that either because you used a false and egregious misnomer again, creating another fucking crime while trying to extort me and fleece me of my life source energy and my securities generated in my good name that you seemingly are willing to hide in the CRIS system while attaching a QSIP number to it. Oh yeah, I got your ass. Gotcha. Fucking love you little criminals. You know, in the 22nd century, you could fucking retire in about a month going around fucking with public officials because they do the dumbest fucking shit because they literally are trained in nothing. Nothing. So, let's go on. If you read the if the judge is stupid enough to actually throw you, actually follow through with his threats to send you to jail, you will soon be released without even being arraigned, and all charges will be dropped. This is malicious prosecution. This is cruel and unusual punishment under the 8th Amendment. And again, I can't tell you how important it is to study the Constitution. This shit's just all off the top of my head. And rightfully, all your offspring, if you're doing your fucking duty as a trustee of the Heavenly Father's creation, your offspring, if you're doing your duty, they can recite this shit off the top of their fucking heads too. The 8th Amendment, excessive bail and bond shall not be set, and cruel and unusual punishment shall not be had. Alright? Innocent until proven fucking guilty. I mean, somebody's got to put their nuts on the chopping block. Under the Real ID Act, they need to use their full legal name, include their address, their phone number, and their fucking email. So if they falsified a record, you have the ability and the means to go ahead and bring suit. Okay? It's value and consideration. You're going to bring a claim, you bring value and consideration, make sure that I have the same opportunity you are utilizing through the court system that I am not privy to, such as electronic fucking filing, you fuck sticks. Alright? So I want your fucking names, your addresses, your phone numbers, and your fucking emails. Let's get this shit show on the road. I'm ready to fucking become wealthy. I'm ready to take your fucking house, your 401k, your 801k, your cars, your trucks, your fucking land, your kids' fucking college funds. I am ready to liquidate your fucking estate. Let's do it. And then I'm going to sit back and first, I'm going to let the Treasury get theirs first because we want to make sure the Treasury's made whole. Treasury, you go ahead and fuck them up first, and I'm going to come up and clean up the rest of whatever the fuck you don't take from them. How about that? One thing they're not immune from is the IRS, the Internal Revenue Service. All right? Okay. So, charges will be dropped, and then you will then have document prima facie grounds for a false arrest and false imprisonment charges against him personally in his private capacity. All right, as a man, you can't sue a fucking judge, but you can damn sure sue the fucking man acting in the capacity as fucking judge because he's the one that caused you harm. And then if the gun-toting fucking moron follows his fucking orders without case precedent, finding of facts, conclusion of law, that motherfucker's wrapped up in it too. All right, it's called human trafficking, and it's an executive order violation. All right. Title 26 USC 7701A1, person. The term person shall be construed to mean and include individuals, trust, estate, partnership, association, company, and corporation. Does not say man, okay? To include one thing is to exclude all others, okay? When we're talking about law is specific. In the Internal Revenue Code, they say that person has to pay taxes and obey the filing requirements, etc. And most people think that they are such a person, so they do it. But there is a maximum of law that says nothing else. Something else. Latin for of the same kind. Used to interpret loosely written statutes where a law lists specific classes of persons or things and then refers to them in general. The general statement only apply to the same kind of persons or things specifically listed. Examples: if a law refers to automobiles, trucks, tractors, motorcycles, and other motor-powered vehicles, vehicle would not include airplanes since the list was of land-based transportation, and more importantly, because it didn't list airplanes. Okay, the law is specific. Pursuant to the maximum of law, the word individual is another type of fictitious entity, but because the rest of the entities are fictitious entities, and in the rules of the statutory construction, a definition must contain the same type of entity, or it is void for vagueness. Therefore, an individual and a person are different names for a corporation, an estate, a partnership, a trust, okay? But they're not a man. They don't apply to you. Title 15 USC Section 44 even provides for an unincorporated corporation. When you do what the color of law statutes say, you are deemed to have agreed to the terms of the contract, and ignorance of the law is not an excuse, because equity and equity and imputes an intention to fulfill an obligation. All right, sorry about that. Got a lot of shit rolling around in my head. Sometimes it takes me a second to get it. This is consistent with what the courts are saying. A person is a variety of entities other than human beings. Human being monsters. That's really not of any relevance if you understand what Black's Law Dictionary says about human beings. But then again, whose words are we using? What dictionary are we using to define these terms and conditions? We need to have a meeting of the motherfucking minds before we can do anything, and that means we need to go word by fucking word to find out exactly what the fuck you're talking about. All right, because your version of understand is definitely not the common knowledge of the word understand by the general populace. Okay? B, foreign not citizen United States versus Otherson, the word person and whoever include corporations, companies, associations, firms, partnerships, societies, and joint stock companies. Title 1, USC Chapter 1, Rules of Construction, Section 1. A sovereign is not a person in a legal sense, and as far as a statute is concerned, in common usage, the term person does not include the sovereign, and statutes employing the word are normally construed to exclude it. Wilson versus Omaha Tribe, Will versus Michigan State Police. Also, a sovereign is not a person in a legal sense. In regards to Fox 52 NY 535, and jurisprudence reports. All of this is consistent with the 14th Amendment because the 14th Amendment talks about a person being a U.S. citizen, and both of them are corporations. Other terminologies which mean the same thing, pretend legislation, and then it would also follow that offenses under pretend legislation, remember, an offense, they're offended. You did something that offended them and now they want to punish you for it, and that violates the 8th fucking Amendment again. Cruel and unusual punishment for not being able to substantiate an actual crime or how their statutes actually fucking apply to you, the sovereign man who created government for man's benefit, right? The slave doesn't get to come to tell master how the fuck this shit show works, all right? We have the right to alter our form of government at any fucking time we feel like it. And it really doesn't need altered. It needs stood upon. You need to stand upon it and smack their asses with it. For any statute to be legitimate, there are certain requirements. For example, it has to have a preamble. It has to be approved by both the House of Representatives and the Senate. And it also has to be approved by you, consent of the fucking governed, and signed by the President. And there are other requirements as well. The lack of any of these would make it color of law. Remember, they're always using color of law to hem you up. Color of law means it does not have authority. Although it has the appearance of law, it is not in fact law. Therefore, you have to agree with it. It is a contract. That is why it is prima facie, which means it is a at first look. In other words, at first look, the courts presume that the statute affects you, but if you can show that you didn't agree to it in some way, then you are free to go. Because the U.S. Congress purgers did their Foreign Sovereign Immunity Act, and also because state citizens are foreign to the United States. Most people think that they have to go through a lot to prove that they did not agree to one of these so-called contracts, but the opposite is true. Color of law and prima facie and presumptions are all associated with admiralty maritime law courts. Still don't believe that the court view these colorable codes, rules, and regulations as a contract? The right of the individual are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agency of the government. City of Dallas versus Mitchell, 245 SW 944. Now that you know the hidden evil in the word person, try to stop using it in everyday conversations. Simply use the correct term, man or woman. Train yourself, your family, and your friends to never use the derogatory word person ever again. This can be your first step in a journey to get yourself free from all state control. The prima facie basis of a counterclaim is that a commercial instrument, such as a promissory notes, credit agreements, bills of exchange, and letters of credit, checks, are defined as legal tender, or money, by the statutes such as Title 12 U.S.C. subsection 1813 I-1. The unpaid balance of the money or its equivalent received or held by a bank or savings association in the usual course of business, and for which it has given or is obliged to give credit, either conditionally or unconditionally, to a commercial checking, savings, time, or thrift account, or which is evidenced by its certificate of deposit, thrift certificate, investment certificate, certificate of indebtedness, or other similar name, or a check or a draft drawn against a deposit account and certified by the bank or savings association, or a letter of credit or traveler's check on which the bank or savings association is primarily liable, provided that without limiting the generality of the term money or its equivalent, any such account or instrument must be regarded as evidence the receipt of the equivalent of money when credited or issued in exchange for checks or drafts, or for a promissory note upon which the person obtaining any such credit or instrument is primarily or secondarily liable, or for a charge against a deposit account, or in settlement of checks, drafts, or other instruments forward to such bank or savings association for collection. Okay. UCC subsection 1201-24, money means a medium of exchange currently authorized or adopted by a domestic or foreign government. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more countries. Official comment. The referenced official comment notes that the definition of money is not limited to legal tender under the UCC. The test adopted is that the sanctions of government, whether by authorization before issue or adoption afterwards, which recognizes the circulating medium as a part of the official currency of that government. The narrow view that money is limited to legal tender is rejected. UCC subsection 3-104, negotiable instruments, Alaska Statutes 45.03.104, UCC subsection 8.1029, financial assets, except as otherwise provided in section 8.103 means I, a security, 2, 1, a security, 2, an obligation of a person or a share, participation, or other interest in a person or in property or an enterprise of a person which is or is of a type dealt in or trade on financial markets, or which is recognized in an area in which it is issued or dealt in as a medium for investment, or 3, any property that is held by a securities intermediary for another person in a securities account if the securities intermediary has expressly agreed with the other person that the property is to be treated as a financial asset under this article. As context requires, the term means either the interest itself or the means by which a person claim to it is evidenced, including a certificate or uncertificated security, a security certificate, or a security entitlement. UCC subsection 91029, cash proceeds means proceeds that are money, checks, deposit accounts, or the like. UCC 91011, chattel paper means a record or records that evidence both a monetary obligation and a security interest in specific goods, a security interest in specific goods and software used in the goods, a security interest in specific goods and license of software used in the goods, a lease of specific goods, or a lease of specific goods and license of software used in the goods. In this paragraph, monetary obligation means a monetary obligation secured by the goods or owned under a lease of the goods, and includes a monetary obligation with respect to the software used in the goods. The term does not include 1, characters or other contracts involving the use or hire of the vessel, or 2, records that evidence a right to payment arising of the use of a credit or charge card or information contained on or for use with the card if the transaction is evidenced by records that include an instrument or series of instruments. The group of records taken together constitutes chattel paper. UCC subsection 910212B, collateral means the property subject to a security interest or agricultural lien being the supreme lien. It supersedes even a first-in-line UCC 1 mechanics lien. An agricultural lien supersedes all liens, and you don't have to give public notice of it, but when the need arises, you can pull it out of your hat and go, here you go, I got superior lien interest. I got an ag lien against this estate, this body, okay? My offspring, whatever it is, your farm grounds, okay? Boom, 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 boom. Where did it go here? Agricultural lien. The term includes A, proceeds to which a security interest attaches, B, accounts, chattel paper, payment intangibles, and promissory notes that have been sold, and C, goods that are the subject of a consignment. UCC subsection 910249, investment property means a security, whether certified or uncertified, security entitlement, security accounts, commodity contract, or commodity account. UCC 910264, proceeds except as used in section 9609B means the following property. A, whatever is acquired upon the sale, lease, license, exchange, or other disposition of collateral. B, whatever is collected on or distributed on accounts of collateral. And C, rights arising out of the collateral. And D, the extent of the value of the collateral, claims arising out of the loss, nonconformity, or interference with the use of defects or infringements of the rights and or damages to the collateral. Or E, to the extent that the value of the collateral and the extent payable to the debtor or the secured party, insurance payable by reason of the loss or nonconformity of defects or infringement on the rights in or damage to the collateral. Legal tender under the Uniform Commercial Code, UCC, Section 102.24, the referenced official comment notes that the definition of money is not limited to legal tender under the UCC. The test adopted is that of sanction of government, whether by authorization before issue or adoption afterwards, which recognizes the circulating medium as a part of the official currency of that government. The narrow view that money is limited to legal tender is rejected. In light of the holding of Guarantee Trust Company versus Henwood, 307 U.S. 247, 1939, a federal U.S. Court of Appeals ruled on Title 31 U.S.C. 5118 as of October 27, 1977, legal tender for discharge of a debt is no longer required. That is because legal tender is not in circulation at par with promises to pay credit. Requirements of repayment of debts is against public policy. Public Law 7310, House Joint Resolution 192 of 1933. Since legal tender was not loaned nor in circulation, they cannot demand payment in any particular form of coin or currency or legal tender, and repayment of payment or payment need only be made in equivalent kind, a negotiable instrument, IBOE, bill of exchange, promissory note, letter of credit, whatever the fuck you want to do, a money order. House Joint Resolution 192 and Public Law 7310, Title 31, USC 5118 prohibits banks' creditors from demanding any specific specie of payment. All banks must process lawful United States currency. Failure to do so interferes with commerce. A felony under the RICO Act, Title 18, USC 1951. Reasons fully stated and cited, sworn under your unlimited liability. Failure to provide lawful reasons or to misdirect this instrument is grounds for a claim to the FTC under the FDCPA, the Fair Debt Collection Practices Act, Title 15, 1692, A1. It is your duty to honor this instrument for payment, to know, abide by, and operate under the law. Title 18, subsection 8, all obligations are obligations of the United States government because a primary active degree of fault is carried by the office of the President of the United States for signing into effect House Joint Resolution 192. Okay? Therefore, absorbing all commercial liability to offset, discharge, and settle the accounts of the American people. Commercial instruments are legal tender for payment of debt in accordance with Title 31 USC 5118. That's the gold standard clause, also supported by Article 1, Section 10. Nothing can be tendered for debt, a payment of a debt other than gold and silver. And other statutes, codes, failures to process and credit the intended account will result in a request of the U.S. Postal Inspector Office to investigate and audit the account's balance sheet, optional, and the file the IRS 3949A information referral to the CID, Criminal Investigation Division of the IRS. Thank you for your participation, and we'll talk to you soon.